Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer, and this is another episode in our series entitled, You Are Practicing Law, Is It Authorized? We are focused on the scope of authority granted to the real estate industry, brokers, licensed members of the real estate industry, by the Washington State Supreme Court in the 1985 decision of Cultum versus Heritage House. And all of our conversation originates with the court's scope of authority as it was granted to licensed members of the industry. I'm going to bring you back one more time to what that scope of authority says. Our decision provides that a real estate broker is permitted to complete simple, printed, standardized real estate forms, which forms must be approved by a lawyer, it being understood that these forms shall not be used for other than simple transactions, which, here's what I want you to focus on, which arise in the usual course of the broker's business, and that such forms will be used only in connection with real estate transactions actually handled by such broker as a broker, and then without charge for the simple service of completing the forms. The court is saying, brokers, you are experts, you are specialists. You know more than anybody else about advising clients with respect to purchasing property, soliciting buyers for property, negotiating those transactions. You are the experts. That is the provision of real estate brokerage services. Determining property values, advertising, holding yourself out as a real estate broker. Those are real estate brokerage services. That is what you are compensated or should be compensated to do. Selecting forms to use for preparing a purchase and sale agreement and drafting the purchase and sale agreement, those are legal services. That's the practice of law, not the practice of real estate brokerage services. You cannot, as a real estate broker, be compensated for engaging in the practice of law. You can be compensated for providing real estate brokerage services. And what the court's scope of authority says is only when your provision of real estate brokerage services results in the need for the purchase and sale agreement or the lease agreement, the services that you're licensed to provide, the real estate brokerage services, advising and consulting in a real estate transaction, only when the provision of real estate brokerage services, when that gives rise to the need for this incidental agreement, only then are you allowed to draft that purchase and sale agreement. So where this particular limitation on the authority comes into play most often is in this scenario. You get a phone call from a friend, a neighbor, a coworker, a complete stranger who says, I want to sell my property. Or I want to buy property. And if I'm the seller, I've already found my buyer. And if I'm the buyer, I've already found the property. And we've figured out what terms we want to include in our contract, but we don't have the forms and we don't know how to write the agreement. Will you write the contract for us? And we'll pay you a flat fee of X. And around the state, for generations, brokers have answered that question. Certainly, I'll write that contract for you. Brokers, that is the unauthorized practice of law. You are not licensed to draft a purchase and sale agreement. And the only reason the court has said that the court will extend authority to you to engage in the practice of law, to select forms and draft a contract, is if the need for that purchase and sale agreement is merely incidental to the real estate brokerage services you have provided to one or both of the parties. Now, if I was teaching a class and you were in an audience instead of on the other end of a camera, I would have a million questions about, well, what if? What if the buyer and seller know they want to do this transaction, but they haven't yet negotiated the terms, and I'm going to negotiate the terms for them? What if I've already been working with the seller, they just haven't listed the property yet, and along comes a buyer who wants to purchase it, but I've already given them a broker's price opinion. What if? And we could spend all day long doing what ifs. And I can't, on this video, on this episode, answer with specificity any of those what-if scenarios, except to reiterate what the court said. The provision of real estate brokerage services has to come first. If the very first thing you're doing is writing the purchase and sale agreement, then I can tell you unequivocally you are outside the scope of your authority. So the provision of real estate brokerage services has to come first. And if it is that provision of real estate brokerage services by you for which you will be compensated, if it is that provision of real estate brokerage services for which you will be compensated, that gives rise to the need for the purchase and sale agreement or the lease agreement, then and only then are you allowed to draft that purchase and sale agreement. But if what you are doing for these parties is drafting the purchase and sale agreement that represents the terms they've already agreed, and you're going to get paid for writing that purchase and sale agreement, then you are way outside the scope of your licensing authority. Does it matter? Because brokers have been doing this for generations. Does it matter? It could. If you are engaged in the unauthorized practice of law, you don't have errors and omissions insurance. Pretty simple. If you otherwise have errors and omissions insurance, that policy does not extend to actions by you that are actions engaging in the unauthorized practice of law. If you have questions on this topic or any other, please ask me a question by visiting warealtor.org, and I'm braced and ready for the questions that are coming on this one. Thank you for being a Washington Realtors member.